The first matter to come before the court this morning is State of Ohio versus Vincent Webb. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. I'm keeping the clock this morning, so if you'd like to reserve that time and let me know when you get started, I can keep you apprised of the passage of time. The court has read the briefs and will ready to proceed when you are.
Good morning, Your Honors. May it please the court, I'd like to divide 11 and 4. My name is Mark Ludwig. I have the privilege of representing Mr. Webb by appointment of the trial court. This is a home invasion, $15 worth of marijuana, $15 worth of cash, and some computer robbery. There were 4 victims, and the state did dismiss an ag bird charge claiming that there was any reckless inflicting of physical harm. So it's not a question that, other than the trauma, obviously, that there was any physical harm caused during this burglary robbery. This is a case of identity. There was one victim, Mr. Farmer, who saw the second individual, who is Mr. Webb. They knew the first individual. They did not know Mr. Webb. Mr. Farmer says, I saw him, finally admits, about 8 to 10 seconds. Ms. Reynolds says, was given a photo array, and she saw a fellow she thought she was 75% sure was the guy, and she saw a fellow in the photo array that maybe was the guy. Of those 2, neither was Mr. Webb. Now, the other 2 victims who were in the room were not called to testify, so we may fairly presume that their testimony would not have helped the state on the issue of identification. How does Mr. Webb come to be identified? There's a 1 photo ID based on a Facebook page. I certainly have no expertise in Facebook, nor am I inviting the members of the court to try this. But the transcript on page 84, the premise was, we got Mr. Webb's photo by way of putting in the words free real and doing a search. And Mr. Real was a short version of the name of the person that they found out was the full name of the person that they knew by face. And the testimony at page 84 was, the minute we did that, up came Mr. Webb's page. Your Honor, I can't get that to happen. Again, that may well be because I don't even have a Facebook page and I'm challenged by push-button telephones. The identification issue we've raised in basically all the assignments, 4 of the 5 assignments of error. We've raised sufficiency of evidence, we've raised manifest weight. I don't intend to waive those arguments, but they're written and they're said. Do I frankly think that the least law impacting approach in this case is the manifest weight argument? Yes, I do. But the good arguments, I think, that really warrant this court's attention are especially the jury charge issue. At what point is it plain error that a trial court should say, look, this is an identification case. Under the jury instruction rules, I'm required to expand on eyewitness identification. It takes no formal citation for all of us to recognize that eyewitness testimony is the #1 cause of wrongful convictions. We know that. Now, here we've got a case that from the beginning is an eyewitness case. Please, the facts of this case in the context of why it was plain error not to charge an expanded eyewitness charge are very important. That's why those facts don't necessarily apply to every case where the guy says, or gal, that wasn't me. It's not that kind of misidentification case. Remember, from the outset, the first appointed counsel in this case filed a motion for an appointment of an expert witness. That's in the record. The trial court ruled, well, give me an idea who it is and how much money you want to expend, and we'll approach that issue. That lawyer leaves the case, the current trial counsel gets on the case, and that's never pursued. That's one fact. From the beginning, it was clear that trial counsel was trying an identification case. But do we have any motion to suppress? No. Do we have any objection during the trial to anyone's identification? No. Do do we have any cross-examination on this issue of Facebook? Here's where the expert comes in two folds. The importance of the expert was to just generally get across to the jury the problems with eyewitness identification. But that's not the only, quote, identification area where an expert would have been important. An expert would have been important on confronting this Facebook issue, on how you get to someone's photograph on Facebook. I was in good company. I felt when I read the trial transcript, the trial counsel and I, neither of us knew how to navigate our way through Facebook.
How would that have affected the identification issue?
The Facebook photo becomes the basis of, oh, I saw his photo on Facebook. I took it to the police officer. He pulled up the photo on Facebook and I then made the identification. Standing alone, that doesn't, but it's with all the other identification problems. At that point, why doesn't the officer say, well, here, you're telling me this is the guy. Let me pull up 4 or 5 photos for an array here in the police station, not based on a one-on-one photo that you say you found. The officer doesn't do that. Maybe the fact that the other witness was 75% sure and maybe on 2 people that weren't even Mr. Webb was an important factor. But that's just a factor in how we get to the identification of Mr. Webb. Now, undoubtedly, well, he was clear at trial, you know. Mr. Webb, the only guy sitting there, do I really need to explain that to this court? Mr. Webb, the only guy sitting at the defense table, is pointed to and said, oh yeah, that's the guy that was there. But it's that final identification is the product of everything that led up to that. So, you know, what we have is a failure to suppress, a failure to have an expert attack the identification, a Facebook identification problem, and I'm sure this isn't the first time, both with Detective Garrow or with other detectives, that this court's heard, oh gee, we made the identification through Facebook. I think that is starting to happen all the more often, where it may be important next time we do a word search, 9th District and Facebook, more than 2 or 3 cases come up.
How is the Facebook issue any different than saying you went through somebody's photo album and you found a picture of a party and this person's face was in the party and you said, that's the guy right there in that photograph?
Because
how is Facebook any different than?
Well, for one, I can pull up, you're going to admit that photograph, that book. If you say you looked at it, you're going to get that book itself and bring it in. For 2, it's not, you're not going to have to search a computer and find a link that I suspect doesn't happen, Your Honor. When you insert free reel, you don't get to Mr. Webb's Facebook page. But that's what they said they did at page 84. Now, again, I don't expect trial counsel or myself, in hindsight, to be able to say, there's a lie. But have you had an expert witness with you? That Facebook thing is a dodge, Your Honor. Okay? It's
in what sense?
In the sense of it probably didn't happen the way they described it. You can't do it that way. All right? You can't put in the words free reel. You may get Mr. Reel's Facebook page. And you may then go to his friends list and you may find a photo of someone. But that's not what the witness said at page 84 of the transcript. He said, I put in free reel and I got Mr. Webb's page.
Well, is free reel a tag name?
Now, Reel is the short name of the first person who they knew who he was. Apparently, like the victim was IB Streets or IDA Streets. And he also, the way it's explained is when you go looking for someone who might be incarcerated, using the words free Whitmore may get you to the page so I can help post bond for you. And that's apparently how they're using Facebook these days. Again, I don't know. The sentencing errors, the ineffective assistance is charged with the jury charges.
Can we then move back to the jury charge? Mm-hmm. Since we're talking about plain error, are you espousing a bright line rule wherein it's plain error for the court to fail to give?
No.
Because we're talking about plain error,
It's plain error when? It's plain error when there's two trial counsels, and the first one appointed seeks an expert, and then the follow-up lawyer doesn't get it. That's going to narrow the application of this case quite a bit, Your Honor. But plain error is not just a broad, bright-line rule I'm suggesting this court adopt. I suggest plain error arises in the context of the facts. In a case where the defendant comes to court and says, I didn't do it, and if I did, you took evidence from me unfairly. That's not this case either. This is a from the get-go identification case. That's important for the plain error test. Again,
Well, okay, so I'm the trial court, and no one's asking for the additional instruction, and trial doesn't go by way of, we have experts talking about eyewitness identification ID. We don't have all that expanded testimony because counsel didn't bring it forth. So I'm just grappling with why is it an error that the court didn't, on its own, include an expanded eyewitness.
well, first of all, Ohio jury instructions suggests they should. That's kind of a hint. I'm not saying that this trial court is perfect, but you do have some obligation to take a peek at the jury instructions before you give a charge. Again, this was a pure identification case. When we're putting together our identification, the state certainly can say, well, we want to have a complicity charge, and they get the complicity charge, and there's not even a question raised by the trial court. Yes, is it defense counsel's obligation to request it? Yes. Will you let me pass the buck only to defense counsel? I cannot, Your Honor. Our trial judges are too darn good and too able to follow this court's directions when they're given.
And you are now reaching into your 4 minutes of rebuttal time.
I will try and preserve what's left. Thank you, Your Honor.
May it please the court, Helen DiMartino on behalf of the state of Ohio, the appellee, we are asking that this court affirm the decision of the trial court. With regard to the issue of identification using Facebook, the state would argue that finding a picture on Facebook is like finding a picture in a photo album. The pictures that are put on Facebook are just that, just a regular photograph that anybody can upload. I don't know any reason why you would need an expert to testify about Facebook. I believe the minimum age on Facebook's webpage for a person to have an account is 13. So Facebook is certainly something that's being used by teenagers all the way up to older adults. With regard to the testimony as to how Mr. Farmer and Ms. Reynolds found the picture, the testimony on page 84, 85, 91, 207, and 211 is that they searched Mr. Norwood's Facebook page. So Darrell Norwood was the main person involved in this case. His nickname was Rell, R-E-L-L, and the testimony was that they looked up his Facebook page, and when they found his page, on it was a picture of Mr. Webb, and that's how they ascertained who it was. And Ms. Reynolds called the police and said, we believe we know who he is, here's a picture that was on this page, and then they found it. So you don't have to have, if it's used for identification, you don't have to have that exact same Facebook picture to come into court and say that was a valid ID. And there's nothing in the record at all to support counsel's assertion that it didn't happen the way Ms. Reynolds and Mr. Farmer said it did, that if you type in Norwood or Rell, that his picture would not come up. There's certainly a number of ways to find somebody on Facebook. If you don't have a Facebook account, you may not be able to get into somebody's account. There's different privacy settings. You could have had it set to, who knows what. So just because counsel couldn't find it doesn't mean that it wasn't there. Also, as soon as someone's indicted, generally those Facebook accounts are taken down or altered, which is why we generally get warrants to get into the Facebook account and the information that was there before the indictment. But there's absolutely nothing in the record to show or to cause any inference that Ms. Reynolds or Mr. Farmer made up that whole issue of looking on Facebook and finding the picture of Mr. Webb. With regard to the fact that Ms. Reynolds identified with 75% accuracy somebody else, That's in the record, and then afterwards, when she saw the picture of Mr. Webb, they both witnesses testified that they had no doubt that's who it was. Neither of the men involved in the robbery were wearing a mask. Mr. Farmer testified that he got a good look at the second man. Ms. Reynolds again testified that the second man, who she identified as Webb, was the person who had the gun. She identified that they had Mr. Farmer on the ground while they took items. So they were both able to see these to see the defendants. None of them had anything prohibiting view from their face. The testimony is in the record that they used Facebook to find who this person is. It's up to the jury to decide whether or not the witnesses were credible.
Was there something in the record regarding the use of the firearm that Webb was pictured holding on the Facebook page?
There's something in the record that indicates that the person on the Facebook page identified as Webb was holding a gun that looked like the same gun.
But and I could be completely on a different planet here, but I thought I remembered some statement about the use of the firearm being used in a robbery. Nothing came up and was given to the jury regarding that type of testimony in your recollection?
I don't recall. Mr. Ludwig might have a better recollection than I do on that fact.
It could be another case.
No, it could
We get a lot of Facebook identification.
I know, I think I read somewhere that the word Facebook shows up in over 75% divorces now, whereas a few years ago it was like 35%. So Facebook is certainly causing many new things. With regard to this expanded identification jury instruction, counsel hasn't articulated, to my understanding, a standard as to when a trial court should sua sponte give this expanded identification. He's arguing that this case from the get-go was an identification case. I suppose that a defendant can argue that in just about every case. Most of the time the defendant doesn't say, yes, it was me. Usually it's, it was me, I wasn't there. So I don't think that that's a right line rule that we can apply. There's nothing in this record that would show that the trial court committed plain error, not sua sponte given an expanded instruction when two witnesses testified that they saw Mr. Webb. Mr. Webb was not wearing a mask, and that they identified him through Facebook, that they knew Mr. Norwood, and this person was associated with Norwood on Facebook, just like they were together during the robbery. So there's nothing in the record that would support that in this case there was any plain error not giving this jury instruction, especially not sua sponte. If there are no other questions, I would rest on the brief.
Well, on that jury instruction question, taking it to the ineffective assistance argument, which is the final assignment of error, to the extent we have some I don't want to characterize it, to the extent we have some identification issues in this case, and the only real evidence we have are the victim witness IDs. Can you speak regarding the ineffectiveness of counsel to not bring forth eyewitness testimony issues and problems and requests for jury instructions in that regard?
Well, there was a general instruction given with regard to that, so I don't think it's ineffective assistance. If there's no bright line rule that trial counsel violated, then counsel really cannot be ineffective for not doing it. Trial counsel was within what's expected of a competent attorney. He asked for the general instruction about witnesses, and that it's up to the jury to decide whether or not they're credible, etc. There's no bright line rule that says that whenever identification is an issue, or because somebody at 75% maybe identified somebody else, but then later when they saw the right person said, I'm absolutely sure that's the right person. Plus, Mr. Farmer never wavered on who it was. It was just Ms. Reynolds who wavered. Mr. Farmer always said, once they saw the Facebook picture, that Mr. Webb was the second person who had the gun.
Did I recall saying that there was some communication between Mr. Webb and Mr. Farmer on Facebook as well?
Mr. Webb and Ms. Farmer, they knew each other. Farmer.
And Webb.
Oh, I don't recall that. No, I don't recall that. It could be in there, but I don't recall that. Mr. Farmer said that he didn't know Webb, that he only knew Norwood, which was Rel. So there could have been correspondence between those two. But I don't recall Farmer and Webb. There's nothing else I rest on brief. Thank you.
Counsel, you have 3 minutes, 40 seconds.
Justice Schaefer, if it please, there was communication. Mr. Farmer started emailing, or through Facebook. Yeah, through Facebook. And saying, you know, I know it wasn't you, but can you help me get my stuff back? And Mr. Webb replied. And they blew that off at trial on the basis of, well, we all knew that Mr. Farmer was really fibbing when he said it wasn't you. He was just trying to get Webb to say something. So there was that degree of communication.
And that's in the transcript as well.
Yes, it is, Your Honor. All the other pages of the transcript that counsel referenced I don't have, but on the issue of identification, at page 85, and I think earlier I vehemently said page 84, at page 85, Mr. Farmer testified. So I went on their Facebook and I typed in free reel and Vincent Webb's name came up. That is, again, one of those issues that's beyond me in terms of Facebook, but that's not how it's described later that it happened. But that's what he said. I'm very hesitant to go to this bright line invitation. I'm resisting the bright line on allied offenses with multiple victims. I don't think we should have it there. I've raised that in the sense that, and I'm resisting the invitation for this court to draw bright lines as to when further examination, further jury instructions should be given. I think jury instructions clearly says that when it's clear in opening, closing, and cross-examination of witnesses that we have identification issues, the fundamental expanded jury instruction which is available should be given. It's not for us to argue to you that, gee, the evidence is this or that on the identity. That should have happened with a jury. And when closing argument came, I hear, well, he requested certain charges. I've kind of checked the transcript. I don't see defense counsel requested any charge of any kind, let alone a general charge on credibility of witnesses. And that's exactly what OGI says, that that's not good enough in an ID case. So, is there a degree of speculation? There certainly always is on what would happen if. But
could it have been defense counsel's strategy, though, to show?
That's not tactical, Your Honor. Yeah, that's not tactical. There's a lot of things, the majority of which can be called tactical. But not giving a jury instruction that favors your client that the Ohio jury instruction book suggests should be given is not tactical. Not when your whole ID.
Not requesting a jury instruction.
Yeah, not requesting it. And not when you're, again, if you're doing a different case, if in opening statement you don't say, wasn't my guy, they can't prove that. If in closing you're not trying to argue that. If your cross-examination of every witness goes to identification and then you fail to object, because every time a witness says, oh, that's the guy, or I was sure, raise the objection. Remind the jury that this is the issue.
And Mr. Ludwig, I need to tell you that you have utilized all of your time today.
Thank you, Your Honor.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website.